all. Thank you all. Thank you. Right. Hello, everyone. Good afternoon. My name is Kunhao Liang. I'm now a PhD researcher, a PhD student at the European University Institute in Florence. It's a pleasure to be here, and thank you, Giuseppe and Professor Wu, for giving this excellent chance for a junior early stage researchers here to present. And it's also great because two of my CUPL professors, where Charles Chengxin and we studied before, are also here. I feel like another thesis defense. And I hope you have a proper coffee to wake you up after the lunch at the Mensa, and try not to make you fall asleep. So today's my topic is 50 years on, is EU-China legal cooperation at a crossroads? So why 50 years? This year marks the 50 anniversaries of the EU-China diplomatic relations. And this is a topic that tried to set the scene for how we understand the Belt and Road Initiative and how we look forward to the future of the Belt and Road Initiative. So first of all, as I mentioned that this year, the year of 2025 marks the 50th anniversary of the EU-China relations, and earlier in May, the leaders exchanged message to celebrate this important landmark of the bilateral relations. And this is how I'm going to present here. First, I'd like to have a look back to what happens in the past 50 years between the EU-China relations, what is the latest dynamics in the bilateral relations, and then I move forward to the present situation of any room for legal or institutional cooperations, what kind of opportunities and what kind of challenges facing the both sides. And in the end, I will conclude with what the EU-China is moving forward, especially with the BRI in the center. So there is a very famous phrase to describe the EU-China relations from honeymoon to marriage, which was used by a few European colleagues in 2007. That is true, and even more in the topic at this moment, that we all know that the marriage time may be a bit more complicated than a honeymoon at the very beginnings, and this is exactly what the reflection of the bilateral relations. And based on that, I'd like to, so how we look into the past of this from honeymoon to marriage, how to better understand what happens in the past 50 years. Here, I'd like to quote Professor Kong Qingjiang in his very important monograph in 2012, which was published in 2012, that he provided us with divided the time that between the EU-China into 3 phases, at least, at the time of 2012. The first period is 1975 to 89, and then 89 to 95, and 95 to, at that point, 2012. And why is this divisions? I try to refresh us with this time period. The first period starts from 1975, when the EU-China entered into the first, at that time, the community entered into the first legal agreements with the People's Republic of China to establish the diplomatic relations. And after that, in 1985, another agreement about economic promotion agreement was entered into force in 1985. However, because of the domestic pressures in 1989 occurs in China, the European-China relations also face more difficulties at that moment. And Professor Gong described that as a transition, a time of transitions. Both sides at that time readjust their strategies, readjust their approaches to each other, especially facing the problems occurred during the end of the Cold War, as well as the fall of the Communist Party regime in the Middle and Eastern Europe. And after that, from 1995 on, Professor Kong defined that as a new period. Why is a new era? Because at that time, in 1995, the European community at that time published the first overall China strategy, which called, as you see, a long-term policy for China-Europe relations. So that is a time, a landmark that to tell the EU is the first time to have a more structural, more systemic approach about and relation to China. However, we see that even though 1995, that was an important landmark, from 1995 on, the community and later the European Union published more than one China strategy and renew its strategies from time to time. And there are so many dynamics occurs since 2012 on. We see the leadership transitions in both sides. The European Commission aims to be the first more geopolitical commission, while in the China also some priority changes. And there were more concerns about the industrial competitiveness, supply chain security. Externally, the Ukrainian crisis, as well as the China-US trade war, is facing both the EU and China, especially at this moment. And also, as mentioned in panel one, the Chinese is more active, engaging in the global governance, such as the Belt and Road Initiative we are talking about, and the trade disputes from solar panels in 2013 to, at this moment, electric vehicles one between both sides. So there are so many new dynamics occurs between those sides. And how do we look into it? I would like to remind us of first of how the EU look into the EU-China relations and what is the renewed approach from the EU towards China. So in 2019, another landmark China strategies was issued by the European Commission as well as the High Representative. It defined China as not only a cooperation partner, a negotiating partner, but also an economic competitor and a systemic rival. That's really raised the eyebrows of Beijing, that what does it mean, a systemic rival, right? A systemic rival can mean that this is ideology, or this is between the different lism or different governmental system. So, but this is how the EU redefine China as a partner, a competitor in the markets, as well as systemic rival. And following that, if we would like to know more about how to what the EU do as a follow-up. So from the partner aspects, the Commission said, yeah, we have to keep cooperating with China in climate change. And the Commission mentioned here the Paris Agreement, the 2030 Agenda, and also the commitment, the shared commitment to international peace, security, sustainable economic development. However, more importantly, from the competitor and rival aspect, it is mentioned that, yeah, the EU would like to have more reciprocal market access and also raise concerns about industrial subsidies, and would like to have a more open procurement market in China, as well as would like to strengthen the EU's competitiveness and ensuring a level playing field, including AI, battery, supply chains, and security, critical infrastructure, and technological basis. So all in all, the competitor and even rival aspect has raised many topical questions that facing the EU, and EU would like to address these concerns or these complaints with China in this approach. And later in 2021, the Commission renewed a trade policy document. And it's interesting that the title of this trade policy document is An Open, Sustainable, and Assertive Trade Policy. And one of the reasons why the Commission implied that it's going to renew that is that the rapid rise of China, demonstrating global ambitions and a distinct so-called state capitalist model, has fundamentally changed the global economic political order. So that is the reason why the EU has the intentions to renew its trade policies to achieve what it already mentioned in the Chinese strategy. And at the latest developments in this regard, that the European Commission released the de-risking China strategy. So what does it mean de-risking? It is a concept in relation to, or to set aside, to have the distance from the decoupling China. Means that, and the Commission, President of the Commissions gave a speech in the Mercato Institute, which was sadly sanctioned by China at this moment, that the China is becoming more assertive and the EU has the necessity to renew the China strategy. And that is what it would like, the EU would like to achieve, is to de-risk, but not decouple. And what the final aim of this strategy is to rebalance the relationship between the EU and China on the basis of transparency, predictability, and reciprocity. So these very political languages what does it mean? Yeah, right. As a lawyer, we'd like to know what does this mean in the legal sphere, and we go a bit further into this document. Is further explained that what the EU would like to do. So they would like to take the steps to de-risk. It includes the diplomatic de-risking and economic de-risking. So diplomatic de-risking means keep engaging with China, keep talking to the Chinese leadership, keep engaging with Chinese civil society to ensure that we were heard. The Brussels is heard in Beijing. However, it may not be enough to achieve what the EU would like to raise the complaint. So it continues with economic de-risking. That means that to make the EU's own economy and industry more competitive, to better use what the EU legal toolbox has of the trade instruments, to develop more defensive, so-called defensive legal tools for critical sectors like batteries and AI, and to align with other like-minded partners. Here is very important, like-minded partners on the economic de-risking strategy. So to use the EU FTAs, BITs, other extra EU agreements to achieve the EU's goals to rebalancing the EU-China relations. And here it mentions the very important, the global gateway strategy, which is a counterpart, which seems to be an alternative offer to the developing to the global south compared to the Belt and Road Initiative. So in the shadow of China, the EU released de-risking China strategy, and as an action points, a European economic security strategy was released in the same year of 2023. And we can see that almost the same policy language was used in this strategy, that the EU would like to enhance its legal toolbox to better protect itself, as well as to work with the partner, the like-minded countries, to address these concerns. So as a lawyer, if we look into all these policy language, and we see that in the recent years, these policy languages have been translated into legal language, and a series of legal tools are introduced by the European Commissions and adopted at the EU level in the shadow of China. Even though none of these legal tools name or targeting China, they did not expressly saying this is anti-China legal instruments, but all the instruments has the shadow, or behind the instruments there were concerns about China, which were mentioned in the policy documents we just introduced a bit earlier. So we see that there are at least 4 dimensions here. The first one is to address the so-called competitiveness concerns and over-reliance on China. So the EU introduced at least the foreign direct investment screening framework, the very soon coming outbound investment screening mechanism, as well as other legal instruments in relation to the critical raw material control to reduce reliance on the China. And the second part is about the market reciprocity, which requires more open market access from China. And by some Chinese scholar, it was defined as the conditional market openness. And one of the examples is the International Public Procurement Instrument, which requires the China to further open the procurement markets for the European companies, as well as other legal instruments like the foreign FSR, the foreign subsidy regulations, and the anti-coercion instruments. And the other instruments regarding the supply chains control, like the due diligence instruments, as well as the economic investigation that to uphold a level playing field for the European market in China, such as the recently open investigation about the Chinese electric vehicles, which is now under discussions to settle down the dispute. So all this legislation does not remain only on the paper, it's also being used in actions. The ChatGPT, I asked the ChatGPT for a table to help me to showcase that under the FSR, the foreign subsidy regulations, as well as the IPI, the international procurement instruments, how many cases has the EU initiated in the past 2 years regarding or targeting the Chinese company? As we see, we already have, since this legislation were adopted, almost all the cases targeting Chinese companies operating in the EU market. And 2 days ago, the last slide here, you can see that the European Commission concluded the cases, which is the first cases under the procurement instruments that ban, in the next 5-year ban, the Chinese company entering the internal markets for the public procurements in terms of the medical device, these sectors. So that is a way that the EU adopting the legal instruments as well as taking legal actions by investigating Chinese company in the EU market to achieve a de-risking strategy in the legal language. So based on what I have briefly introduced, is there still any room for the legal cooperation or institutional dialogue between the EU and China? I think so. So it is not, what I introduced is not a way to be pessimistic. It's just a way to take stock from of what is happening, and then on that basis we can look forward. So from that side, from the tensions or the competitor sides, we still have partner sides. So as I mentioned, 1985, the EU-China has the first trade and cooperation agreement, which in the language is very general and the policy language, but it's a landmark, it's the first one. And after that, after so many years, there is a trade agreement on geographical indications. We recognize the geographical indication from both sides, which to promote the IP protections as well as the trade. And another, maybe most of you have heard that the comprehensive agreement of the investment, which was concluded in 2020 as a modern BIT between the EU and China. However, due to the sanctions in relation to Chinese Xinjiang regions, it was frozen, and until now it's still frozen. And other than the bilateral level, there are other legal achievements in multilateral or plurilateral levels, like the Paris agreements, the China-EU in the climate actions is taking joint efforts, as well as the MPIA, the alternative dispute settlement system under the WTO, also reflects and other examples that the EU and China work together to maintain the multilateral system. So is there any room for China-EU to work together? And now we turn to the Chinese side, which Professor Kong is the Dean of the Foreign Related Rule of Law School in the CUPL. And this, in the recent years, the Chinese president proposed a structural framework of the foreign related rule of law. What does it mean? As the president said, it aims to promote the foreign related legislation, law enforcement, justice, legal compliance by public and legal services in a coordinated manner. And this foreign related rule of law is the recent documents or recent policies that China is adopted to address the external or the risk, legal risk come from outside of China. So would there be any chances that the foreign related rule of law is to some extent aligned with the values or the strategies that the EU mentions in relation to China? That would be a question to answer. And how would this foreign related rule of law to reshape or to enhance the Belt and Road Initiative in the future? That would also be a further questions. So a questions here I would like to open up, but maybe not to be answered at this point, but for the future is between the Chinese foreign related rule of law and the EU's normative projects, right? The EU, some scholars define the EU as normative power Europe, market power Europe, or some scholars in the US define it as Brussels effect, the global reach of EU law. Whatever you call it, the EU's claim itself as a normative power, a rule-based, a rule of law power. And how would the Chinese foreign related rule of law and the EU's normative projects can have the shared interest or share the room for further cooperation institutionally? So that is a question I think would be interesting to answer in the future. And as Ellen Fahey mentioned in her book, in her monograph in 2022, actually, so the EU is establishing or enforcing the substantive or procedural rules supported by mechanism of including oversight, accountability, and legitimation in line with fundamental rights protection and internal values. That is to some extent different from what we have discussed in the BRI project, that we maybe to some extent prefer a more flexible, more efficient, more pragmatic cooperations offered to the global market. So that is two different projects. However, is there any room for cooperations? And I believe so. So there will be some parts that at least in some areas, that there can be alignment between the two sides. So here I show two kind of analysis about the Belt and Road Initiative from the European scholar, how the European scholars look into the Belt and Road Initiative. So Professor Giuseppe Martinico, in the monograph about the Belt and Road Initiative, already provide us with some insights that, as he defined, the BRI is not an international organization, and it does not claim to represent an exhaustive and institutionally autonomous phenomenon. It's one country, one approach strategy. It's vary from the legal uniformity achieved and preserved by the Court of Justice of EU and the legal system. And furthermore, Professor Alan Fahy further defined this as a so-called law-light, institution-light, treaty-light, top-down regulated efforts. So that is probably how the European friends and colleagues look into the Belt and Road at this point. But however, it doesn't mean that the Belt and Road Initiative is totally an anti-normative framework. It's still a normative framework, but may have preference in its mechanism, in its enforcing mechanism, and in its take a different strategy in order to achieve its goals. And if we take a look at how many European member states at this point still participating actively in the Belt and Road, there are still some. So in total, there are 17 EU member states signed a memorandum with China in relation to the Belt and Road. Some countries left or terminated the cooperation. However, there are still at least some countries from the Central and Eastern Europe actively participating in the Belt and Road, and we see the infrastructure will build, as mentioned by Professor Kong this morning. And Italy sadly terminated the memorandum in 2023 because of external and internal pressures. However, it doesn't mean that the Belt and Road Initiative is the end of it. It's too early to define that. So it will see the different normative offers by the EU or vis-a-vis the offer by the China between the EU Global Gateway and the Belt and Road Initiative, how much it will be a choice from the Global South countries. And also, interestingly, it was mentioned today by Professor Li, and in the first panel, the IO map, that which I think is another way how we look into the normative framework provided by China. The International Organization of Mediation doesn't mean that it is only focus on an anti-normative. It is not. As mentioned today, it's also a public good or choice for the parties, for the countries in the world to settle down the disputes in an alternative dispute settlement mechanisms. As in the remark by our foreign ministers in Hong Kong last week, that it mentioned that it draws upon the strength of being more flexible, cost-effective, convenient, and efficient. So this is, if you can see, this is the features mainly upheld by the Chinese as another alternative options for the global world as a normative choice to settle the disputes. It may not necessarily to be a contest to the ICJ or other judicial system. It is an alternative good, and we will see how it will work in practice in the future. Coming to the end of my presentation, I would like to conclude with a maybe more optimistic optimistic attitude to see what is the future between the EU and China. On May 8th, the president of the European Council addressed in the EUI. I asked him a question personally. So how would he look forward to the EU-China cooperations between the partnerships between the rival and competitor? And he gave us a very optimistic answer. He said he thinks that there's a good political science between the EU and China. Is a common will to be more partners and less rivals. And the importance of multilateralism, the importance to preserve international law, the importance to preserve global committees like Paris agreements is highlighted in his answers. So this may, at this point, when the US adopt the reciprocal tariff policies, that will be a chance that the EU and China rapprochement to re-engage, to achieve to see what the values and interests is shared between the both sides. So one of the examples actually between the EU-Chinese scholars to move forward to locate where the EU-China have shared interests is a recent China-EU joint initiative on WTO reforms proposed by the Chinese EU European WTO lawyers to uphold WTO systems amid this global trade war between the US and China. So we'll see how it works, and that would be more and more institutional attempts to maintain the global efforts in the multilateralism. I think this is where the Belt and Road Initiative, as well as the more broader gender that between the EU-China will achieve in the future. This is my presentation. Thank you so much.
All right. First of all, thank you so much to the organizers for this amazing workshop. And I would also say thank you so much for these very interesting presentations. I mean, they're so great, so many good things coming up that I don't know if I have anything to contribute with here. When I was asked for a title of my presentation a little while ago, I was not thinking about the EU. I was not thinking about China. I was thinking about Trump. So I thought, okay, let's wrap this into something with Donald Trump, because he affects very much my country at the moment, Denmark. I'll get back to that in a bit. So opportunities and challenges of the Belt and Road Initiative in a dynamic global legal order. What I also want to say is that I will bring forward some ideas. It's a bit theoretical about what could be considered. I'm quite optimistic about the China-EU relationship. And in particular now, in light of current issues in this global order. Now, what it is I want to address here, and that's also something that should not be understood, because I'm going to draw a bit on economic theory. So I'm not going to talk so much about law. The law would be there, but the theories would be around it, using transaction cost theory. And transaction cost theory, it is from new institutional economics. Transaction costs should not be confused with Trump's transactional approach in international relations. I'll get back to that. The theory that I will address here is one that normally will apply between businesses. So, and here we talk about states. So therefore there will be a lot of reservations, and I'm at very, very early stage with this idea. And I'm going to end with some questions, actually. So it's not you going to ask me questions. I'm going to ask you questions that hopefully you can help to bring my research forward. And perhaps not today, but give it some thoughts, and then just write to me with the good ideas that you might get that can bring this research forward. Okay, right. But first of all, I would say when we look at the Belt and Road Initiative, and from a trade perspective, the idea is brilliant, because what does the Belt and Road, what does it do? It is improving infrastructure, and improved infrastructure means also that trade can go much faster from country to country. So it will work well from businesses in their supply chain. They will get their goods faster. From a WTO law perspective, aiming at international trade and the flow of it, we could say, okay, it's also meeting some of the objectives of WTO law. But there's this, however, and a lot of the things what I have on this slide, it has been addressed already today. The EU-China relationship from an EU perspective, I should also say that when I represent an EU perspective, it's not necessarily that I share some of the EU fears that there sometimes are, because sometimes I also think that what we hear in this rhetoric from an EU side, as well from Chinese side, it can have to do with position of powers in international relations. So a lot of things can be said, and then all these good things that go on under the surface. But we heard it before. I was mentioned China as a systemic rival. That is also reflected in the EU anti-dumping policies from in 2016. This change, expected change, that China had not been treated as a market economy was going to change, and it did change, but it's still not treated as a market economy. Instead, it got a new wrapping called distorted economy. Then there are differences in the human rights approach and barriers to trade and investment. From the EU perspective, say that it's very difficult to enter the Chinese markets. The Belt and Road Initiative, now, what are the intentions of the Chinese government behind this? We heard earlier today a Chinese perspective here on it. But the EU, and I don't know if it's a European thing, it can be a Danish thing. Sometimes I wonder, and it's also my experience, I would say, with China and Hong Kong, to give you a very good example of it. When I did my PhD, I was in Hong Kong. I stayed in a hotel apartment for 9 months. I had a contract, and I had to pay rent every month. I knew what the rent was. Okay, that's it. 1 month, I got the bill, and the price was lowered. It cannot be. I thought contract here immediately. They're going to cheat me here. So when I leave this place at the end of October, they're going to charge me with an extra bill with interest to it and so on. That was sort of my idea, and I contacted the administration immediately and asked, what has happened? Why have the rent, why is it lower? That's not according to the contract. And that's where I had to open my eyes to, there can't be other than this westernized contract perspective and things. The price was lowered because they thought I was kind to the staff working there. That's not something you normally would see in a Scandinavian context. You would never go to Denmark and the price is the price. No one will lower it for you, regardless of how nice you are. So what's the intention of the Chinese government when it comes to the Belt and Road Initiative? This uncertainty, it's something that we have to think here. There is uncertainty from the EU perspective on what is it China wants with this. And is there a way that China perhaps can make this uncertainty, lower that uncertainty and make things clearer for the Europeans? Now, that's a bit on the EU perspective to the Belt and Road Initiative. Let's get into the changed geopolitical landscape, because I think it's important also when we look at the EU-China relationship. Now, the US, we heard about the transactional approach, short-term gains, unilateral short-term gains, hard bargaining approach, and this view that institutions, they are in the way for this unilateral approach. Trump doesn't like the institutions if they don't do what he wants. From an economic perspective, as we've also seen how markets have reacted to it, they have not performed very well to this transactional approach. Because markets, it's about risk. And the higher the risk, the more the markets will deviate from a balance. And economic uncertainty will affect the markets and the agents of the market in a negative way. When it comes to international law, and we heard some very interesting presentations today, and I should also say, generally, my approach to international law, I take a constitutional approach to it. I'm quite soft when it comes to that. But of course, I cannot ignore what's happening right now, moving a bit into some realist thoughts. Because international law that's based on good faith. We don't have a higher ranking policeman who can go after states if they don't comply with the law. Or they can do it and say, oh, kick you out of this institution. And that state might say, well, I'm so powerful, so I don't care. Now, complying with international law, it's a moral duty that states they have. And when we look at morality here, then we have to look at the leaders of the states. Coming back to my friend in the US, now his level of morality is not as high as the one we saw with, for example, Obama. Obviously, in previous presidents of the US. It's a very different approach. And that is the transactional approach. What works for me, that's how it should be. The unilateral gains, use law if it can give something to the US. If it cannot give something to the US, break it. That's the challenge that we have with international law as it is right now. The principle of friendly relations, which there are between China and the EU, it's not really there at the moment between the EU and the US. So, and that's what I mean here, that the US friendly relations towards the EU is moving to something I would call unfriendly. Trust that has been built up for generations, it takes no time to eliminate that trust. And that trust is eliminated as it is right now. As a Dane, as it is in Denmark right now, we are threatened from two sides. From the east, with Russia, Danish fighters are quite often in the air because Russian fighters are getting very close to Danish airspace. So we have issues. It is not a direct aggression yet, but let's just say we're sort of preparing for it. To the west, we have the US economically aggressive approach towards Greenland. Greenland is part of the Danish realm. And we have had a very close relationship with the US in respect of security and their use of Greenland. But this approach of taking over, now, first of all, you cannot just buy a nation. I mean, and you cannot go to the Danish government and say, want to buy Greenland. It doesn't work like that, because Greenland, that's for the Greenlanders. Okay, that would be their choice. It's not something the Danish prime minister can decide. But nevertheless, that is what we are up against at the moment. So for the EU, we are there at the moment between Russia and the US. And that brings me then to China and the Belt and Road Initiative. Well, seeking dialogue, seeking win-win situations, that is, I would say, even more open now based on the current situation that we face with Russia and with the US. We can disagree politically, economically, culturally, etc., have ideological differences, but it does mean that we cannot have friendly relations and perhaps do something to improve the trade relations between us. Now, of course, one thing that, and in particular in Denmark, there's focus on, that is the China-Russia relationship. But perhaps when I read Danish newspapers and they say that, oh, China supports Russia, I'm not necessarily sure that China does support Russia, but it might appear so. And there we come to, we need a better understanding of these cultural and ideological differences with China, the Chinese approach, giving face to others. Okay, don't show anyone that they lose face. Give face and have this with the network. And Guangxi, I don't know how to pronounce it, but that can explain China's position towards Russia. What happens behind closed doors, we don't know. What Xi Jinping, he tells when you have meeting with Putin, we don't know that. So strengthening the ties with China, it's one possibility, and I have to move on because I need to get to the theory. The uncertainty, now from the EU perspective, the uncertainty about China's intention when it comes to the Belt and Road Initiative. Is it a win-win position, as we heard promoted earlier today, or is it about China being dominant? So that brings me to borrowing from Williamson's transaction cost theory. And that, as I said, it has nothing to do with transactional method of international relations theory. The transaction cost theory, it's about institutions, building institutions. And it comes from back in the 30s, where this very clever guy, Coase, he asked this question, that if economists, they say that markets, they always work well, that's the best solutions. Why do we have institutions? Why do we have firms? Why do people organize then? It must be because there are some costs of using the markets that we make these designs of these institutions. I should also say a few other relevant words when we come to transaction cost theory. One is about asset specificity. Investments that are valuable only within a specific relationship. That means that if you take it out, you lose. So when we have heavy investment in ports, facilities, for example, these can be considered as sunk. You cannot just take them back again or change it to something else. Now, the theory also works with uncertainty. So how can we organize the governance here to reduce uncertainty between two parties? And it also has this assumption of opportunism, that actors, they are self-interested. So that's what I will get back to. But first, I'll just say that the difference from Trump's transactionalism, that is that with transaction cost theory, we minimize transaction cost by making appropriate governance structure. Whereas Trump's transactionalism in international relations, it's about maximizing short-term gains unilaterally and being as tough as you can be. Very different approach to institutions. Institutions in transaction cost theories, they are there to lower the costs. That's why we have them. We have to cooperate. That would be the best way forward. Whereas the Trump approach, institutions, they are just in the way for the unilateral benefits. Now, if we take transaction cost theory into the Belt and Road Initiative and talk about asset specificity, now that is, for example, all these infrastructure projects. They are asset specific because, again, their investment into something that you cannot get this investment back again. However, if this is going to work, there is the risk of asymmetric dependency. It's not enough that it's only one party here that will benefit from it. We need to have both parties benefiting from it. And that is where the EU will have these concerns about Chinese ownership or control over critical infrastructure, including ports. And what we heard also before about procurement, the fear of non-transparent procurement, debt diplomacy, and lack of reciprocity. The EU approach, I'm not going to say too much about it because it's been said already, but there's an investment screening mechanism to identify, assess, and mitigate potential risk to security or public order. That is where the EU can go in and change the current investment situation. Encouraging transparency, the EU-Asia connectivity strategy, for example, and preference for hybrid governance structure, like, for example, public-private partnership. We have already some institutions in place. The WTO is always there. We know China will comply, the EU will comply. Let's just not think about Trump in this respect here. As long as it works for the EU and China, it's there as an overall, getting to the time now. So now the EU has some involvement also, or EU states. Asian Infrastructure Investment Bank, we heard that earlier today, that the several EU members, they have a seat there, but we still need more. And that more brings me to my final point of Williamson's theory. Taking and giving hostages. It sounds very dramatic, but what it is that China and the EU respectively will give something valuable that one party voluntarily put at risk to signal commitment and build trust with the other party, because it's a signal to show that you can trust me, and that can be part of reducing the uncertainty. So my final slide here to the question, and you are more than welcome to come back to me with this. What does China look for in the trade relationship with the EU? That's one question. And the second question, which specific assets can be interchanged as hostages between China and the EU? Thank you very much.
Thank you so much, Professor, for your super insightful and interesting presentation.
Thank you.
Now I give the floor to David. Feel free to change seats if you want to.
I'll just take it.
Okay. But there's a remote, I guess.
Yeah.
Okay.
So to kick off, thank you very much for having me. It's such a pleasure to be here with some old colleagues and now new colleagues and new friends. My name's David. I'm associate professor at the School of Law of Chongqing University, which is located, as many of you know, in the giant megalopolis of Chongqing. And I'm also associate research fellow of UNU CRIS, working on regional integration, but primarily water resources. So you might be wondering a little bit what I'm doing here. We've seen a lot and heard a lot about investment and trade and WTO and business and EU-China relations, and then you stick on this water guy at the end. And so what I'm going to do is perhaps challenge you a little bit to think more broadly about the Belt and Road Initiative and more broadly about the legal context that the Belt and Road Initiative finds itself within. I'll touch on a few of the themes from this morning, including soft law and norm development. But I'll maybe look at how the Belt and Road Initiative tries to work in currently existing legal systems. Just skip this since we're getting short on time. So when we think of the Belt and Road, you might think of this hub and spoke network that is comprised of both hardware, those infrastructure projects, and software, your institutions and your non-binding instruments. This definition comes from Wang Heng, who's now at Singapore Management University. And you might think of this beautiful map filled with roads and railroads and ports. But when you start to look beyond these types of investments, you will see that there are other types of infrastructure that it also included, and that these different types of infrastructure interact with very different international, but also national standards and the standards of different international institutions. So when I look at the Belt and Road Initiative, I see water uses. I see uses of water resources. I see potential polluters. I see potential energy infrastructure primarily. So when we look at some of the research that is found on what is included in the Belt and Road Initiative and what is considered as a Belt and Road infrastructure project, one of the things that we find in the research is hydropower projects. So there's significant investment that researchers include as a Belt and Road project, including hydropower dams across several continents in South America, in Africa, in Southeast Asia, and in Central Asia. And that this makes up a large portion of the energy investments that are part of the Belt and Road Initiative, around 39% from the year 2013 to the year 2021. Now, this might be a bit of a new topic for some of you, so I'll just give a little bit of background about the way that transboundary freshwater resources are governed in international law. So many of these hydropower projects that we had mentioned just in the past slide, they are constructed on a transboundary freshwater resource. It's something that's shared between 2 or more states, and there are around 313 international watercourses all around the world. They cover almost half of the Earth's surface. They encompass over half of the global population and 60% of global freshwater flows. And around 150 states are sharing some type of water resource with a neighboring state. If you think of the membership of the UN, we have 193 member states. 150 of those are impacted or have the need to cooperate over freshwater resources with their neighbors. But this is just the surface. We can go even deeper. And there are around 500 transboundary groundwaters, really depending who you ask. The International Groundwater Resources Assessment Center uses a lower number, around 468, I believe, whereas the UNECE will use a higher number, 592, really based on how you define a groundwater resource. And when we look to international law that applies, we have 2 global water conventions, or they are both framework conventions. On the left, we have the 1997 Convention on the Law of the Non-Navigational Uses of International Watercourses. And on the right, we have the 1992 United Nations Economic Commission for Europe Convention on the Protection and Use of Transboundary Watercourses and International Lakes. Now, these are multilateral framework treaties that provide a broad set of rules that can be then applied more specifically within a specific watercourse. And it should also be mentioned that some of the provisions that are found in these conventions are codifications of custom. But there's also a lot else going on. And so when we look a little bit more deeply at these conventions, well, we see that there are a common set of rules, and these common sets of rules can be found across many regional, multilateral, and bilateral agreements. So when we talk about substantive rules in these agreements, we have the principle of equitable and reasonable utilization, where you have to share the transboundary water resource with your neighboring states and decide how to do so based on a variety of factors and come up with an equitable and reasonable use. And also the due diligence obligation not to cause significant harm. There's also a variety of procedural rules, including regular information exchange, prior notification for planned measures that may cause harm, such as a hydropower dam, for example, and consultation. Now, as I'd already mentioned, some of these are custom, but this all exists across a spectrum of bindingness. So this morning we talked about soft law, In a paper that I wrote, I used the word softness because we don't just, we have soft law, that's a very non-binding kind of type of instrument, but we also have treaties that also exhibit levels of softness through the way that specific provisions can be implemented and the kind of the flexibility that states have in doing so, or even binding treaties that include non-binding provisions. So I like to talk about softness instead of soft law. And so I like to talk about in international water law, this spectrum of bindingness. But we really need to also think more broadly about what international water law is. And this is kind of how I connect it to the Belt and Road Initiative, since we can start to talk about the nexus of rules that apply to these water projects, including international investment law, but also the standards and guidelines of international finance institutions. And so I'll briefly give a talk about the Lancang-Mekong River as a case study. Now, the Lancang-Mekong is shared between Cambodia, China, Laos, Myanmar, Thailand, and Vietnam. It starts in the Qinghai Tibetan Plateau and flows south into the remaining 5 states and flows out into the South China Sea at the Delta in Vietnam. And all the states who are on this river have developed significant levels of hydropower. There's around 164 hydropower projects that are found throughout the river on the mainstream as well as the tributaries. And the governance structure of the Mekong is significantly fragmented. We have a binding agreement. We have specific agreements on some procedures, including information sharing. We also have the Lancang-Mekong Cooperation, which is one belt of the Belt and Road. And we also have different standards for finance institutions and more. Here's just a picture of all the major hydropower dams that have been installed on the Lancang-Mekong. So as one example of Belt and Road infrastructure, but we also had it mentioned earlier today, the Funan-Teco Canal, which is just starting to be constructed. However, all of these projects kind of have legal challenges for implementation of the host state of their obligations under international water law. So the Funan-Teco Canal, for example, is required to undergo a PNPCA process, prior notification, consultation, and agreement with the other states of the Mekong Agreement. But the way that they're presenting the Funan-Teco Canal is that it's not a mainstream project, therefore it doesn't have to go through those procedures, but the other states in the region would disagree. So when we look at the legal landscape of this arm of the Belt and Road, we have the 1995 Mekong Agreement. This is the only binding agreement that applies. And it largely is reflective of the approach of the Watercourses Convention. Those agreements were being drafted around the same time. It established the Mekong River Commission, but the problem is that it's never going to be able to fully govern the river because it only includes the 4 lower states as their parties: Cambodia, Thailand, Laos, and Vietnam. China and Myanmar are not party, but they do participate as what they call dialogue partners. They participate in the processes of the Mekong River Commission, but they're not obligated under the treaty. And China also shares information by agreement with the Mekong River Commission since 2002. And that has been slowly expanding over time. And when we take a closer look at the Mekong Agreement, we can see, though, that when we talk about transboundary water treaties, we have 5 key elements that we can look for. We can talk about scope, we can talk about substantive rules, procedural rules, joint institutions, and dispute settlement. So in terms of the scope, the agreement talks about the basin. In terms of substantive rules, it has those different, it includes equitable and reasonable use, as well as the due diligence not to cause significant harm, but kind of differentiates between the rules that apply to the mainstream and the rules that apply to the tributaries. For procedural rules, we have a list of areas of cooperation, but these are really developed through non-binding procedures, those soft law instruments, which would govern the processes that these projects have to go through, like the PNPCA process. Joint institutions that establish the Mekong River Commission, and in terms of dispute settlement, you can either settle your disputes through the Mekong Commission or through resolution by the governments. Now we get to the real, more of the core of the Belt and Road connection, and that is the Lancang-Mekong cooperation. Established in 2015, it's considered a spoke of the Belt and Road Initiative, connecting China to the rest of Southeast Asian states through this institution. And the institution takes what they call a 3+5, when it has now been expanded to 3+5+X. And that they have three pillars, 5 cooperation areas, one of which is water, and then plus X for whatever we feel like we'll add on to it in the future. Now, unlike the Mekong Agreement, all states are party or are participating in the Lancang-Mekong cooperation. And it takes a project-focused path towards cooperation. Like this morning, we talked about non-binding instruments and how the BRI is developed through that. The LMC is also developed through non-binding instruments that come out of leaders' meetings, which happen every 3 years, and foreign ministers' meetings, which happen annually. And when we take a look at some of these instruments, we start to look a little bit more closely. They start to illustrate their relationship with the existing agreements in the river basin. So we can see that they try to insert these norms into cooperation through, for example, the 5 principles of peaceful coexistence that we talked about today, that China has very clearly stated it views as basic principles of international law. But it also says that it recognizes the existing legal frameworks that it enters into in that agreement, or into that region. And so when we see these agreements, we can see a very common approach to the recognition of other legal instruments. You'll see this very similar paragraph across almost all of the instruments. That this the Vientiane Declaration, for example, reaffirms the principles of consensus, equality, voluntarism, mutual consultation and coordination, common contribution and shared benefits, respect for the UN Charter, the ASEAN Charter, and international laws. But it also can do more than just work alongside these rules. It can also, as a non-binding instrument, I like to say that these softness and these non-binding instruments are not legally binding, but they can have legal effects. So we can see how it tries to work alongside international law when we've talked about these other instruments, but it can also help us to fill gaps when those international laws are unable to govern the entire river, for example. And we see this trying to occur by a reflection of some of the international water law norms that are customary international law. We see reflections of equitable and reasonable use. We see mention of the due diligence obligation not to cause significant harm, which was a later development as downstream states were really concerned about the impacts of hydropower and that the impacts that hydropower were having. And we also see a very strong emphasis on information sharing and these procedural aspects of cooperation. But its project approach can also go beyond what is currently within the realm of international law to develop international legal norms. Now, we see a strong emphasis on mutual benefits, which is another way that you can, fulfill your obligation to use the river in an equitable and reasonable way. Instead of saying you get 50%, I get 50%, we can say, well, I'll build the hydropower dam, but we'll give you cheap electricity and share the benefits in that way. We also see a really broad approach to water resources, which links it to other things. And finally, it offers opportunities for collaboration through joint projects and encouraging states to come up with joint projects and then providing funding for those joint projects. But these infrastructure projects are at the nexus between international water law and other areas of international law, including international investment law. So we also have to take into consideration the various bilateral investment treaties that China has with the neighboring states. It has one with each of the Mekong states, is listed on the bottom here. But ultimately, I'm going to kind of go through this quickly, we're running out of time, that ultimately these rules are for investment rules are for the investors and the host state, but the water law rules are for the host state. So we see this kind of disconnect between the way that investments, which affect the use and utilization of a water resource, are governed under both investment law and international water law. And we should also consider different standards of international investment institutions. So if you think of the World Bank, for example, they have their guidelines for projects on international waterways, which requires, for example, prior notification of other states, regardless of the impacts of the infrastructure project. But Chinese investments come from a variety of different sources. We have MOFCOM can be an investor. We have different development banks, including ICBC. We have state-owned enterprises. And Exim Bank, for example, was the main infrastructure financer in those in Laos hydropower installations. We see China Road and Bridge, which is the main financer and constructor of the Funan-Teco Canal. Now, they all have their guidelines on environmental standards and their social and safety guidelines. However, only the China Exim Bank has released them publicly. So when we look at these guidelines for environmental and social impact assessment, we can see that there are requirements for EIA. There are requirements for social impact assessments, consultation, and a variety of other mechanisms that are meant to assess the project and minimize some of the risks. But like I said, ultimately, international water law obligations are for the states that share the water resource, but international investment obligations are between the investor and the host state. So in conclusion, I think the BRI, when I was preparing this presentation, I really didn't know what the BRI is. And because everyone talks about it in a completely different way. And I really didn't know what's included in the BRI, because we talk about roads, we talk about railroads, we talk about ports. Some people talk about hydropower. Some people exclude hydropower. I see Professor Kong this morning listed hydropower in the economic corridor section. So I really am not sure what the BRI is. And we've all talked about it in very different ways. It's dynamic, it's a cooperation platform. It's meant to connect China and the world. I think we really need to narrow down a definition of what BRI is. But I think it's gone much further than its original mission to connect China in that hub and spoke network. It's really kind of becoming more of a development initiative in some ways. It's very interesting as other countries pull back from their aid and development in other projects that the BRI continues to finance projects around the world. So we've looked at, in this illustration, we've talked about transboundary hydropower. We've talked about these different gaps. And I wonder if this might require a higher standard of due diligence for both of these parties on the behalf of financiers to ensure that their projects are able to meet standards and rules within international water law, but also for states who are obligated by international water law to also take due diligence to ensure that the projects they accept within the BRI will be able to continue and to be able to meet those standards, minimizing risk for both China as a financer and Chinese institutions, but also risks for BRI states. And just in conclusion, this presentation is kind of the connection of multiple things that I've been working on over the past years, primarily this paper on softness, but also some work on hydropower and investment and a hydropower checklist with some colleagues. So thank you very much. And thanks to my colleagues on the panel.
Or you can come here so the camera can catch you. Yeah.
My question addressed to Dr. Yang. Actually, I'm very thrilled by your presentation. I wonder whether there's a possibility for China and the EU to collaborate in the WTO, for example, by establishing a WTO without the United States, W plus minus one. The possibility, I think, is there. Of course, I would like to hear your observations and your insights. Yeah. Thank you.
Thank you for the question. Oh, yeah, we can collect more and Giuseppe, you want to add something?
Yeah. You might first.
Repeat offender.
All right, so first question to Kunhao. You mentioned extraterritorial application. How do you see a clash taking place between the way Europe applies its rules extraterritorially and the Chinese way? And how do these two interact in practice within the context of international law? Second question to David. I mean, you knew they had that coming as well. How does the soft law Lankang slash, because that's the interesting case, the Lankang Mekong. And so you have the Lankang there mechanism, and then you have the Mekong Agreement, and then you have international water law, and then you have out of the two conventions, you have the Watercourse Convention that is signed by 4 of the 6 countries there. So how do these...
One of the 6.
One, sorry, it was Vietnam, yes. So how do these two... Because one and two are binding, one is soft. But the general context, it's international water law. So how do these two binding slash soft interact in the context of international water law?
You mean between?
Yeah, between both, where international water law, in this case, the Watercourse Convention is being used sometimes as supporting one claim and others different claim. These are my questions. Thank you.
I also have a couple of questions, especially for Kunhao. And my first question is, could you please tell us a bit more about your very last slide, when you mentioned the joint initiative, EU-China, for the reform of the World Trade Organization? That will really like to know more about that. And the second question that concerns the relationship between what you call the foreigners, how is it called? The foreigners related rule of law, and the very concept of the rule of law enshrined, for instance, in the Chinese constitution. Is the latter a broader concept, and can the former be traced back to the later, or are these two concepts different? And so can we see here the emergence of a kind of the polysemic nature of the concept of law? I'm curious to know what you think. Thanks indeed.
Other questions?
Are there any questions? Thank you so much. Now I'll give the floor back to you.
All right. Thank you so much for professors and for all the questions. That's very big questions, very hard. We try to provide some of my insights. So maybe John's questions about the WTO. So first, the John's initiative on WTO reforms is recently co-drafted by the Chinese WTO lawyer, Professor Yang from Tsinghua University, as well as John Clark, who used to be the head of the EU to the WTO. So there is a joint academic draft of initiative to uphold the WTO reforms. And I think one of the most important and interesting thing behind that joint initiative is that the Professor Yang from China, the Chinese professor, used a EU document, a European Commission's WTO reforms document as a basis, and work on that EU document to see which part could be accepted by Chinese policymakers, which part need to be polished. So on that basis, they co-drafted another version. So that is which aims to be much easier to be accepted by the policymakers from both sides. So that is an academic draft which aims to be tabled in front of the policymakers ahead of the July summit between the EU-China's leaders, but we will see how far it goes. So I raised that example is that because it is a case to tell that there were more institutional efforts between two sides to find in the area like WTO reforms, which have the shared values or interested at least in some sectors or parts that can be found between two sides. And I think that's a good case. And also related to WTO, Professor Kong raised a very big and important questions. I think in the past few months, there were discussions regarding this EU-China joint initiative of WTO reforms, and there were some European scholars mentioned that maybe the US will actually leave the WTO at some point, and what should the EU and China and the rest of the world do? And there were some scholars, some colleagues said, it's fine, we still have 70%, more than 70% of the EU, the rest of the world, so we focus on each other. And for the China, I think it's the same. There would be a possibility that at some point the trade talk may not go somewhere, and there would be the worst case that the US officially quits the WTO trade system. So in that case, what would the EU and China cooperate, or what would the EU and China do? And even though that even behind in the WTO areas, there are still many areas that, for example, in the trade and sustainability regarding the CBAM, the carbon border adjustment mechanism, and the human rights related topic, that there will be many differences between the China and the EU, but the both sides still remains a key part and the fundamental upholder of that system. So I think this makes the EU-China stay in the WTO as a pillar. And aside from WTO, also the platform like CPTPP, which may also be an alternative for the both sides to work on. And we see that China is ready, the Ministry of Commerce already announced to reform in line with the CPTPP as a higher standards economic rules for China. So that would make China more in line with the EU standards for reciprocity, for market access, but that would take time. So that may be an external factors to drive the EU and China to stay in the WTO or other plurilateral platforms that may work. I hope that is some thoughts for that. And for the questions about the extraterritorial effects of EU law or the Chinese law, also about the foreign related rule of law, I think, so the EU is famous for the Brussels effect, or the so-called global reach of EU law, which means that the law has become an instrument as an maybe not weapon, but as a tool to achieve the policy objectives outside of the geographical borders of the EU. While China, in the past years, the laws largely remains internally within the borders of the geographical borders. So I think the foreign related rule of law is also approach to enhance the Chinese legislation or the capacity to extend the rules to some extent outside of the Chinese border to achieve the policy objectives in line with the international law. And this is what the EU is good at doing, keeping in line with the WTO rules as well as the public international law, rather than the US style overreach of the law. And so there, but however, if everyone extend their law outside of the border, there will be conflicts, as you mentioned, about jurisdictions, legislative jurisdiction or even judicial jurisdictions. We see in the civil and the climate related case in national courts in the Europe to decide whether the carbon emission outside of the EU is in line with the Paris Agreement or other climate conventions. So that would be extraterritorial. However, this kind of conflict, I think, is happening. However, how the countries to manage them, I think, is still way to see. There is not a lot of cases to see the direct crash between the EU and China at this point. So the last question from Giuseppe is about the foreign related rule of law. So the rule of law is not the first time mentioned in the Chinese constitution, as we discussed before. Back to 2004, China in the revision of the amendments to the constitution, the rule of law concept was already adopted into the constitution. However, it is until the very recent years that foreign related rule of law was highlighted by the president in the policy language and the policy document by the party as well. It provided border concepts that China would like to in line with the international standards and in the course of opening up and the market opening up, as well as the external relations. So I think it's an extension of the concept of rule of law to the areas that China, including the Belt and Road Initiative, to extend the concept, the nature of the rule of law from the Chinese perspective to the Chinese external relations with other countries. So I think it's a extension, but we will see how it will be translated in concrete legislation and behavior. That will be interesting to see. I hope it answered a little bit the question. Thanks.
For Imad's question, which I think I'll talk about in kind of 3 steps. So first is like the Lancang-Mekong Cooperation MRC relationship. And originally there were concerns in 2015 when this kind of arm of the Belt and Road was established that the LMC would eventually replace the Mekong River Commission. I certainly think there's not much concern about that anymore. And there's, so far, at least, the relationship seems to be more cooperative than it seems to be conflicting. So they signed an MOU, kind of a memorandum of understanding, outlining a bunch of different areas that they would cooperate on. They are also working on collaborative studies on the impacts of hydropower in the Lancang-Mekong River. So kind of finding common ground where they can also kind of work with Chinese institutions and get information from Chinese institutions for these reports that are being conducted on the entire upstream and downstream. In terms of the Mekong River Commission and its relationship with international water law, so we see how there's similarities between the Mekong Agreement and the Water Courses Convention, but only Vietnam is really party to the Water Courses Convention. It's only 1 out of 6 states in total, 1 out of 4 of the Mekong Agreement states. Now, if we look to we brush up on the Vienna Convention on the Law of Treaties, treaties only create obligations between states that are parties to them. Since there's no other parties on the Lancang-Mekong, what are the real obligations that are being created here for Vietnam? It's really kind of an unclear question. I'm working on a crazy idea right now of erga omnes obligations in international water law. Maybe that would update some of our legal relationships, but that's a topic for another day. But generally, what I was going to get to next was that they can probably, the hope is that they can probably utilize the agreement as an interpretative mechanism for the Mekong Agreement. I know you've written an article on this, so I feel that you have a lot of comments.
Yeah, feel free. One comment. I don't see Vietnam using this only to interpret the Mekong Agreement. I see, in a way, using international water law binding agreement as a soft law mechanism to push countries there to try to abide by general principles without being bound by international agreement. The same way China uses general international water law principles domestically, but while not signing an agreement. So principles of equitable resource utilization, China agrees on that domestically, but they never signed the Water Course Convention because of questions concerning sovereignty. I think Vietnam is trying to push towards considering the principles within. Vietnam knows that the other countries, including China, will not sign the agreement, at least not in the foreseeable future. But that said, they could try to push to use existing provisions and principles of the International Water Treaty as a soft way to push towards better governance in the Mekong. Not sure that's going to be the case or not.
Well, I think what I'm getting at within my own presentation is that China and the downstream states, through the Lancang-Mekong cooperation, are trying to insert those norms into their cooperation, even though through a non-binding instrument. I don't know about Vietnam's practice. We can talk about that later. But at least what I'm trying to say is that through these non-binding instruments that are created through the Lancang-Mekong cooperation, these BRI instruments, essentially, they're inserting at least an acceptance of some customary international law that would be applicable beyond just the agreement between the 4 downstream states. So I think that in that way, the downstream states are able to get China to say, well, customary law applies here. And we can talk about equitable and reasonableness. We can talk about due diligence obligation not to cause significant harm in that sense.
Okay.
I have 2 questions for my colleagues behind. So questions for Henrik said, I think it's a very important way to examine the effectiveness or how to improve the BRI, that transnational cost approach. And my question is that if we look into the BRI, then as a very doctrinal lawyer, we examine, okay, soft law base, it's soft law, so we look into the text analysis to see whether it is soft law or hard law, whether it's binding or not binding. But when it talks about the cost or the transnational cost, it seems that there would be different factors need to be considered to be taken into account when examines whether it's effective or not, whether it's the costless or not, or how to improve that. So my questions is two sides. One is about the methodologies. So how to examine, how to gather the maybe data, or how to gather the necessary materials before you examine this cost of the BRI or projects under the BRI. Because some costs may be long-term, short-term. The benefit also can be short-term, long-term. It's hard to scope the whole scenario of the costs or the benefits. That's the methodologies. Another way is also related to so the long-term, short-term times. Would you say that you focus on a period, or how to define that time period? Yeah. And another question for David, that I'm very interested in the due diligence approach, because this is the European due diligence instruments requires the companies, the transnational companies, to conduct due diligence in supply chain, take care of their suppliers or the subsidiaries. So I'd like to hear a bit more that how would that due diligence obligation or due diligence approach can be adopted into there's three circles you mentioned. How would that include
You mean into the financing?
Yeah. How would that implement? Would you say like it is the obligation of the institution, the financial institutions, or the investor, or the state under the WTO, in the WTO context? Yeah. Thanks.
I'm also going to ask a question if we can collect some questions. This is for both of you. What is reciprocity in your presentations? You both touched on this idea of reciprocity. So my PhD dissertation was actually on the legal principle of reciprocity, but I'm very curious because it's a political concept, it's a state relations concept, it's a legal concept. We can talk about the general principle of reciprocity in international law. When we talk about as a theory of international relations, for example, some scholars talk about specific reciprocity or diffuse reciprocity. And I kind of hear this in kind of both of yours, where specific is you give me A, I give you the equivalent of A. Whereas diffuse reciprocity is, well, I'll give you A, the other person will give you B or C or D, maybe 10 years from now. Like, it's not a specific transactional. So I'm just wondering what you guys mean when you talk about reciprocity, and what reciprocity between China and EU could look like.
Starting from Professor Andersen to answer the question.
Right. Thank you very much for the questions. The first one about Belt and Road Initiative and soft law, and in light of transaction cost economics. Now, what do we mean with costs? And transaction costs, that will be these costs of using the market. We have already something in place when we have the Belt and Road. It's institutionalized, perhaps not in a strong sense, but from a transaction cost perspective, we will say, okay, some institutionalization is taking place here. Then the question will be about how we should institutionalize it. Should we take it into a very rigid hard law type of like the WTO? Would that be the point to do that? And I think the Belt and Road Initiative, due to the character it has, it's been very difficult. And I think you mentioned also, how do we define the scope of it? because it's not particularly well defined. So that means that from an institutional perspective, we'll say it's very fluid. What I meant to suggest with the use of these ideas from Williamson was not so much about measuring the costs of the relationship between the EU and China, but more thinking about, is there anything in the theory that we can use to decrease uncertainty? Because the moment we lower the uncertainty, or the uncertainty that the EU has in respect of what is it China wants with this, the moment we do that, then I will assume that that will open the door for stronger cooperation. So it was only meant as an idea for that, but not that I would go into empirically and analyze the actual costs of using the Belt and Road in relation to this uncertainty that the EU has. But there will definitely, it's a good question you raised there, because there would definitely be some economists who would go and try to measure what's the cost that we have in respect of, from the economic perspective, due to the uncertainty that the EU has in respect of China's intentions. So it's definitely something that could be done. I'm quite sure someone have done it, but that's not the intention with the work I wanted to do. I was more looking into, and also with these reservations, that this theory of transaction cost, it is usually applied between companies. I was more looking into thinking the stuff with hostages, which of course it's a very difficult. What do I mean with hostages? If we play with this thought, let's say that Giuseppe, he ran a restaurant, and he's making and he's making this amazing tomato sauce, and he's the only one with the recipe. He has it in here, and he asked me, Henrik, will you come and work for me? I don't really trust him. But he could give me the hostage then. He could say, well, I will tell you what the recipe is for this tomato sauce, but you must not tell anyone. But I will know it. And he will know that if I tell it to the world, he could have a contractual claim against me for doing it. But it doesn't matter, because he would have lost it anyway, because the whole world would know it. So that's a hostage that he's giving to me. So and that's more what I was thinking of. Is there anything there with this relationship between the EU and China? Because I am in favor of the Belt and Road Initiative. I think the faster things can go, the better it is. And that is possible through the Belt and Road Initiative. But to have EU opening more up for it, we have to look at the concerns that the EU has in respect of China. So that's more what I was thinking of when we look at EU and China here, and transaction cost theory, more looking at this with hostages and some ideas from that. And as I said also, when I started my presentation today, I'm not even certain that this theory can work. Maybe it can. There are a lot of things that I need to look into, also in respect of the assumptions behind it. But it was just to share some ideas that I have on it. Then there was a question of reciprocity.
If you want some more time to think back into the second question.
Yeah.
So you also asked a question about due diligence. So when we look to the conventions, for example, it's the due diligence obligation not to cause significant harm. So you're under an obligation to take all reasonable measures to prevent significant harm, which is kind of like a standard that's more than detectable harm, but also less than severe. So you're obligated to take that level of due diligence. But I think you really, in asking this question, point to a research area that has not been explored. What is due in due diligence? And it's really not quite clear, I think, in any area of international law. What is due in due diligence? So when we look at World Bank policy, for example, they have their guidelines for projects on international waterways, which is their way of taking due diligence for any project that is on an international river or lake. And they require prior notification for all the states on that river or on that lake, regardless of whether harm is going to be caused or not. So they take a higher standard. And they also strongly encourage the parties to establish an agreement to kind of govern the river or the infrastructure project, to kind of allay any fears and to be able to deal with any legal issues that might occur after. What next? But if we look at some of the practice of the Chinese Exim Bank, for example, on that slide, it includes things like environmental impact assessment, social impact assessment. But here again, we have, well, what's the content of an environmental impact assessment? What's the international kind of standard? What's the obligation under international law? And what's the content of that? Kind of differs from jurisdiction to jurisdiction. So I really can't answer your question, because it really is dependent on what is due in due diligence. But these kind of investment banks, these financiers, incorporate this due diligence through their own social safety standards and guidelines.
Quick follow-up is that when we
Please check.
when we're talking about due, is about standards. So in the conventions, that any list of standards refer to or is left to the parties?
It's left to the parties, essentially. Just prevent significant harm. And then you might be doing that by your procedural obligations. That might be one component of that, but we'll have to get into this later.
Thank you.
Just very limited.
Yeah, so about our reciprocity, I think is very good points that maybe we use, or the EU and China uses in different contexts. I think that I use in the context of the EU's concerns. Reciprocities means that the Chinese companies here has the market access not as equivalent as the market access in China for the European companies. So this is more a political economic terms, but not a legal. It can be translated into a legal claims, but I think this is how it used. While I think another situation, reciprocity, is also used by the U.S. at this point, right? Is about the trade surplus. So that means that A need to equivalent to A, rather than A can be B, can be feel like the same equivalent. So I think it's different, but maybe it's need to be further categorized. Thanks.
Yeah, but be very fast, because again, this principle of reciprocity is not particularly well defined anywhere. So and that's why we come into what we heard earlier today about comparative international law, which perhaps can put some light on what different countries and bilateral agreements, how they understand this principle of reciprocity. But it's both a legal principle, but it's also something, of course, in international relations theory. So I'm going to give you absolutely no answer to it. But I would like to make one final point, a question that came up from Professor Kong about the WTO without the US. If I have a second, 1 second, we have to. The US was part of forming back in the 40s GATT, and has been a very big drive also in the WTO. However, there is a process. There's so much that have happened over the time. We have different actors, so many different actors involved in it. Could we have a WTO without the US? Yes, of course we can have that. It's possible.
Actually, there is that is the 2019 MPIA. EU and China really collaborated in establishing MPIV, certainly to replace the the appellate body, certainly, because of the U.S. block of the appellate body members, and that was paralyzed. The two parties together with others, something like 17 or 16 countries, finally established a PRV, and nothing was changed. No legal framework was transformed. They just retained existing one. Only that, if you want to join anybody, I mean, the system is open to anybody within the WTO. Even the US is willing to join it. It can do so. So legal framework is not an issue. The issue is whether the two parties would like to take into other factors into consideration. For example, EU would like to see that China would change its so-called non-market-oriented policies. China would like to see EU will change its trade policy that target China. Regulations, foreign subsidies, regulations, so on and so forth. Yeah. So I think that might be the legal obstacles. If the two parties can put aside these legal obstacles, certainly they can collaborate. And I do believe if you really want to make the WTO sustainable and relevant to substantiate a free trading system, I think the two parties just cannot afford losing this WTO, this system, multilateral trading system. And this system has been undermined because of the US reciprocal policy. Certainly, the rule-based system has been undermined. And this has been, certainly has been highly valued by EU and China as well. So I think at this moment, it's critical moment, at this critical moment, the two parties may put aside the legal barrier, legal obstacles, and focus on such a normal WTO. They do not want to change anything. They say, oh, please, if you want to join us, you can come. We are going to have a WTO. Even though the WTO doesn't say, oh, anybody shall be excluded, even the US.
But we don't even know if the US withdraw from the WTO
Even it doesn't,
at one point.
As a matter of fact, even the US does not withdraw, and this WTO is still there. The WTO -1 is still there. Yeah. Within the system, all these members are bound by the rules of the existing WTO rules.
Yeah.
That's my point.
Okay. Dear colleague and friend, I do feel like the time, but as you can see, this has been a very interesting and heated discussion. Thanks once again to our wonderful speakers. And now I'll give the floor to Giuseppe and Professor Wu for the final
Okay. Okay, so thanks indeed. It has been a very rich day. Personally, I learned a lot. I took a lot of notes. We are standing between this great workshop and a beautiful sunny day. So I'm gonna be very brief because we wanted just to share some thoughts we have about the result of this workshop. As said, as the professor Wu said at the beginning of this day, this is just one of the I would say links in a longer chain of cooperation. And since in 2009, I mean, we managed to gather very interesting contribution coming from different scholars in this book. Let me show, the beast. This book, which was published by Palgrove some years ago. This is for the picture. Thank you, Kunhao. You are the best as always. So the idea would be that why not? Try to come up with another additive volume. Don't worry. We know that everybody is under pressure. That everybody is very busy, and that's why we wanted to. Actually think of a project with a very let's say, relaxed, deadline. So we're thinking to ask you, to contribute, by sending a chapter by June 2026. So you have 1 year. In the meantime, yours truly and Professor Wu will try to find a good publisher. Our first book has been very successful, so we are sure that we have the material for something that could be even better, and we will be extremely honored to have the chapter of yours in this the collection. This is what I wanted to say. I give the floor now to Professor Wu. I want to say once again, thank you very much to our speakers, but above all, thanks to the Confucius Institute and thanks to the director, to Professor Wu, for making this day possible. Thanks so much. I give you the floor.
Okay, thank you very much. What I want to say is, I just want to thank you all for your insightful presentation and the engaging discussion. And it's a long day, right? Throughout the day, we have explored the Belt and Road Initiative from different perspectives, reflecting on its legal and institutional developments, its achievements, and the faces the challenges it may faces. Naturally, on some issues, we may hold different views or adopt different approaches, but it is precisely this difference that enrich our conversation and push us to think more deeply. And I hope the discussion today will spark new ideas and continue the cooperation in future. Thank you again for being here with us. And thank you for Professor Giuseppe Martinico for his dedication and the support, constant support. And without his effort, this event would have not been possible. Thank you all. And I wish you all a pleasant evening and safe travels back home.
Thank you.